My lord, in item number 7, 8, and 9, I have filed my affidavit, lordship. It may be called for lordship. Oblige.
May I please, your lordship? My lord, I am paying for listing an IA on Friday, lordship.
IA, for
IA,
what?
For extension of time, lordship. 10 days time given to us to file the representation. Due to miscommunication, it was already been over, and they are directed to dispose the matter within 20
Friday.
Friday, lordship. And another prayer, lordship, for withdrawal of that case on tomorrow, lordships. Oblige, lordships.
The Lordship, I beg to mention item 11 of the daily list. The opposite party has not filed the affidavit in opposition, and even the case diary and status report has not arrived yet, Your Lordship.
Today has received today morning, my
Mhm.
received.
Okay. You want to go through it? You are for petition?
For the petitioner.
You want another date?
No, Your Lordship, because it was not there in the court records, the case diary. If there
Yes,
is,
there cannot be in the court record.
oh,
Okay,
if it's there,
Okay.
it may not be adjourned then, Your Lordship.
May it pleases your lordship, with the consent of the other side, I beg to mention item number 20, your lordship.
20. Okay.
Take up-
Miss, you are for the petitioner?
Petitioner, your lordship.
Miss,
S. Sarkar.
as Circle Land Council paying for the petitioner has made a prayer for adjournment of the case for how much time?
Lordship. Can it be listed on 15th June?
No, for 3 weeks. It is submitted that you have submitted mention memo.
Yes, your lordship.
A mention memo is that a prayer is made with the consent of the Land Council for the respondents, and a mention memo to that effect has also been circulated yesterday. First of list the case. The prayer is allowed, list the case on side even.
14 July 1407.
May I please the lordship? Lordship, I beg to mention for listing, for admission, lordship.
Admission, what is the subject matter?
The matter is respondent authority acquired the land without paying amount.
Okay, give it to the court master.
May I please your lordship, I beg to mention item number 19.
Yes.
Humble request for adjournment.
You are for
at-
which side?
Respondent.
Okay, Mr. Bhatra, A. Bhatra, Land Council for the petitioner is present. Miss
P.R. Chaudhary.
P.R. Chaudhary, on behalf of Mr. H. Gupta, Land Council for the respondents. How much time?
2 weeks.
Adjournment?
2 weeks.
Okay, has made a prayer for adjournment of the case for 2 weeks. First up, as the prayer is not opposed by the Land Council for the petitioner. The prayer is allowed, leave the case on so and so.
1706.
Obliged.
May I please the lordship? Lordship, beg to mention item number 22 of the daily list. We have been like by Dr. Ashok Saraf in this matter, lordship, but due to some personal difficulty, lordship, we'd like to seek for an adjournment.
Mr. Rajesh Vaikya. Okay, Mr. You have informed.
Yes, sir.
Mr. Rajesh Vaikya, Land Council appearing for the petition has made a prayer for adjournment with the consent of the Land Council for the respondents. As sought for and agreed to by the Land Council for the parties, leaves the case on
16 July
16.
1607.
any interim order.
There's an interim order, lordship.
Interim order, file extended till land established.
Highly missed.
I am praying for listing this matter for motion on Friday.
But the subject,
The matter regarding the remission of the settlement amount.
the mission.
May it please your lordship, with the consent of the other side, I beg to mention item number 13, your lordship. Lordship, may kindly adjourn the matter for today, your lordship. My physically has some difficulties.
Okay, Mr.
Hey, Goswami.
A. Goswami, Land Council appearing for the petition has made a prayer for passing over the case,
Lordship, there is an interim order.
for the day. Miss,
With the consent,
who is for the respondent, revenue?
not here, your lordship.
Who is anybody in the revenue department? Miss M. Bormon, Land Junior Government Advocate for the state respondents is in attendance. The case is passed forward for the day as prayed for.
Lordship, there is an interim order. with-
Interim order. Past release shall continue till the next release.
Obliged.
May it please your lordship. Lordship, this is with regard to item number 2 of the daily list. Lordship may like to recuse yourself from this matter.
Okay. Reach the case before any other match without me.
Deeply obliged, lordship.
Supplementary list for withdrawal. Item number 25.
Wait, please, now. I. I'll have a look at para 4 and 5 of my application. I. Challenge in para 1, Lord, what we had challenge in the application. Mr. Dubey, you are casting aspersion. No, no, Lord. What we are saying is, Lord, this is second round of litigation. But our situation is such, Lord, even if decided, then again reconstruction would fall. Lord, otherwise,
You file a petition, then till the time petition is decided.
but it is our upon us, Lord, because it could not be decided. So this is the circumstance. Eventually, Lord. it
Art
will-
Mr. R. Dubey, learned counsel for the applicant, read petition, and Miss M. Das, and standing counsel PWD for the opposite party, just respondent.
5, 6, and 7.
5, 6, and 7. M. Bormon, Agosha Koidibo, learned junior government advocate for the opposite party, number 2, 3.
And 8 also, Lord, subsequently implicated the state.
Revenue. Who is present? Z. Hazarik Alliance Training Council, Revenue Department for the opposite party, respond number 8, full stop, para. The instant interlocutory application is filed, instant application is filed by the applicant, thus petition seeking withdrawal of the connected writ petition, WPC number 6752/2024, which have liberty to file a case, if so advised, post of para. The petitioner, the applicant, as the writ petitioner, has preferred the connected writ petition WPC number 6752/2024, assailing an order dated 6/11/2023 passed by the opposite party, that's respondent number 2, for demolishing the building of the applicant petitioner on the ground that the same was damaged due to fire, full stop. The said decision was purportedly based on a report of the Public Works Department, which was not provided to the applicant petitioner, full stop. There was an earlier round of litigation in the form of WPC number 5065/2023, wherein an order dated 31/8/2023, an order dated 20/06/2023 passed by the opposite party, that's respondent number 3, for demolition of the building of the applicant petitioner was assailed, full stop, by an order dated 31/8/2023. In WPC number 5065/2023, the said order dated 20/06/2023 was interfered with a direction to the opposite party, that's respondent number 2, to take a fresh decision in a matter by considering the test report conducted on behalf of the applicant petitioner, which was submitted by the applicant petitioner from an accredited agency suggesting that the building was in a position to be repaired. Full stop. The order dated 6/11/2023, impugned in the connected writ petition, was assailed on the ground that without proper assessment of the test report submitted by the applicant petitioner from the accredited agency, the order has been passed. And the order dated 6/11/2023 is bereft of any region. The petitioner has now averred that as the decision as regards construction of his business premises could not be taken for the reason that the applicant petitioner is not sure as to whether to carry out complete construction or to strengthen the existing building, and the same has likelihood of affecting the applicant petitioner due to possible delay in starting his business operation. First of all, it is in such backdrop the applicant petitioner by this instant application has sought to withdraw the connected writ petition, as with lapse of time the existing structure may further weaken, which may ultimately lead to demolition of the same and construction of a new structure. First of all, in the instant application, the petitioner has averred that he wants to withdraw the connected writ petition with the liberty to approach again in case there is delay by the respondent authorities in demolition of the existing structure or delay in granting permission for a fresh construction. Post of para. Post of. The prayer in the instant application has been made in the following manner. Prayer to Puridiva. The land council appearing for the opposite parties as respondents have submitted that they have no objection if the prayer meets, if the instant application is allowed in terms of the above prayer. First of, having regard to the amendments made in the application and the prayer made from as quoted above, the instant application is allowed. First of. Next, heart so and so. In WBC, in view of the order passed in the connected interlocutory application IS civil number 1726/2026, the writ petition is dismissed on withdrawal, with the observations made in the order dated so and so, passed in IS civil number 1736/2026.
Respondent number 4 has, Lord, is SC Municipal Corporation Board, Sipsagar.
Nobody appears.
Is the difficulty.
You are there?
On behalf of PP the
Mr.
A. Burua.
A. Borua, Learned Counsel for the opposite party, that's respondent number 4.
Deeply.
For motion, item 26.
Yes, Mr. Fukon. It is there. Yes, that day you were not there, so we adjourned the matter. Just a minute. Do you have the copy? I'll just hand it over to, oh no, I have the one. Just hand it over to Mr. Fukon.
My lord, is there any provision that I can get any information from the?
That part, that is a jurisdiction of another high court. That is not possible for us. Okay. I heard Mr. D.C.C. Phupan, Learned Counsel for the petition, and Ms. M. Borman, Learned Junior Government Advocate, Assam for all the respondents. 11/5/2026, huh? First, second paragraph. Then paragraph 3. M. Borman. যিখিনিলৈ আছে পেন্সিলেৰে সেইখিনি when Mr. Goswami, Ms. Borman was requested to obtain instruction as to whether the case record of Hadgaon Police Station, case number 49/2022, has been transferred to the jurisdictional police station for investigation, Ms. Borman has placed a report from the officer in charge, Hadgaon Police Station, report dated 25/2026 of the officer in charge, Hadgaon Police Station. Post of on perusal of the report, it is noticed that the FIR, which was registered as Hadgaon Police Station, case number 49/2020, and which had to be treated as zero FIR, was transferred to Friends Colony Police Station, Uttar Pradesh, in terms of an order dated 9/12/2020, passed by the Court of Learned Judicial Magistrate, First Class, Kamrup Metro, Gauhati. Full stop. As the investigation after transfer of the case record, as the investigation of the case after transfer of the case record, is to be carried out by Friends Colony Police Station, Uttar Pradesh, the petitioner, which is not within the territorial jurisdiction of this court, this petition is closed, the petitioner is at liberty to avail appropriate remedy permissible under the law to seek redressal of his grievances, if any, before the appropriate forum.
No. All right.
Public.
Daily list for admission. Item number 1.
May I please, Lord? The matter pertains to compensation of Jirat. But earlier, the petitioner's land was acquired for construction of railway line. But, thereafter, my lord, the value of the land, compensation of the land and some Jirat has been received. But my lord, only the rubber tree, some rubber tree, which value has been fixed by the authority, my lord, 325.
But court has observed
very
already,
less, my lord.
you have enclosed a T-board, rubber board,
Rubber board.
that
Yes,
development
certificate-
cost of rubber tree.
Yes, ma'am.
When you received the amount,
My lord, in the year 2015.
15,
And I filed with petition.
then you filed a writ petition 2015,
16.
16.
Yes, ma'am.
But did you make any request or
Before the deputy.
agree by lesser amount of compensation?
Yes, my lord, they, my
No,
lord,
2000.
they received the compensation on protest, my lord.
Where?
By submitting an indemnity bond.
Indemnity bond is not protest. It is a requisite to receive the amount. You have to lodge a protest or that, no, I am not receiving this. Send it to the,
Referral code.
those are not made. You accepted it. Now you say that
Value is so less.
value is so less.
Only.
One has to be diligent enough and knowing, not knowing the law is not a pretext. No, 1894 Act.
1894 Act.
Respondent number 2 has filed an affidavit, my lord. I could not make time to see whether it was in record or not, my lord. It was filed yesterday.
I have received.
Is it? Let us see.
The copy may not be available.
Let us see.
My lord, they only says that.
Let us have it.
The affidavit, my lord, page 37. They fix the value as per the order.
Just let me read the affidavit. It is not that the deputy commissioner had approved the rate without any basis. There is an order and rubber plantation is done in Tripura in a big manner. So he has obtained a report from the government of Tripura, approved rate for compensation of rubber trees, and accordingly passed an order fixing that age 6 to 7 years, 325.
That is,
But this report of the rubber board does not indicate when, what expected income during 20 years of tipping lifespan. This is very vague. And secondly, there is no protest.
the order of
What does the Land Acquisition Act says? Which provision, madam?
That is Section 12 in case of 64 Act, my lord, and in case of 13, my lord, it is 64.
No, I think this is 1894.
1894, so 13 Act will follow now, my lord.
No, that is
64.
not
it was pursuant to the earlier act, my lord.
passed under earlier act.
94 act.
No satisfaction.
18,
1894 act.
section 18.
Section 18 was there.
Mr. Ahmed, difficult
18.
No, the
art.
little bit less, my lord.
No,
And-
why, 2016 court has already expressed a view.
The Tripura
On
order, my
10-6,
lord.
on 10,
My lord.
Mr.
My lord,
Ahmed, okay, you have the option to challenge, but on 10-6-2022 itself,
my lord, the order of Tripura, my lord, the state of Tripura, my lord, that is way back of 2011. And our
yes, when the
compensation-
when the LA case was when? 2010.
Then, but the compensation has been, my lord, disbursed in the year 2015.
Heard Mr. S.A. Ahmed, learned counsel for the petitioner. Revenue, Ms. Ann Bordole, learned standing counsel, Revenue Department for the respondent number 1. And Ms. M. Bourbon, learned junior government advocate, Assam for the respondent number 2, 3, and 4. First of all, the petitioner, in this petition, it is stated that the petitioner is a permanent resident of village Morog Dola, non-K, paragraph 1 Moza Hunapur, Post Office Kamala Jari, Police Station Hunapur, Hunapur Revenue Circle, District Kamrup Metro, Assam. Post Office. It is further stated that the petitioner was in possession of two plots of land, measuring 2 bighas, 2 kathas, 10 lessas, and 1 bigha, 2 kathas, 14 lessas, covered by DAG number 41 and 42, and annual patta number 17 and 6, situate at village Morogdola, non-K Mauja, Hunapur Revenue Circle, so and so, District Kamrup Metro. Post of. It is the further case of the petitioner that the family of the petitioner was in occupation of the aforesaid plots of land by paying since the time of his forefathers, by paying government revenue. Full stop. In one part of the two subject plots, comma, which are compact, which are adjacent to each other, comma, the petitioner had constructed his house and was living with his family after taking electricity connection. In the other part of the two subject plots, two plots of land, the petitioner was doing cultivation, poster, para, by paying Tozi Bahira revenue, government, by paying Tozi Bahira, government revenue, Tozi Bahira revenue. The petitioner stated that he planted valuable trees and dug a fishery. You said in paragraph 2 that you have 2 bighas and 1 bigha. Now, in paragraph 3, you have 7 bighas now.
Out of 7
Arrow,
bigha, this
arrow.
2 bigha
Right.
para 10 lesser was
Right, you.
acquired.
In the year 2010, comma, the state government, in order to acquire land for construction of a railway line from Tetelia to Bornihat, initiated a land acquisition process, a land acquisition case, comma, LA case number 10/2010, under the provisions of the Land Acquisition Act, comma, 1894 since repeal, the act for short. Full stop. The Broad Gauge railway line. The Broad Gauge railway line was conceived as an alternative alignment to Ajara-Bornihat, comma, new line within bracket through the villages of Morogdola, comma, Sonai, comma, Kamalajari, comma, Holutari, comma, Homota Pathar, comma, Bornihat and Honapur villages under Honapur Revenue Circle, poster, as the petitioner, as the 2 plots of land which the petitioner was possessing were located in village Morogdola, non-K, comma, it came under the purview of the acquisition process of LA case number 10/2010. Poster. Notices were served upon the recorded patadars and possessors of government khas lands as interested persons who lived in the aforementioned villages to hand over the possession of the acquired land to the district administration, Kamrup Metro. Full stop. For the purpose of assessment of Zirat, field verifications were carried out by the personnel from the district, by the officials of the district, from the district administration Kamrup Metro. Including the officials of the Honapur Revenue Circle and the Railway Administration. In December 2010, Postal. The response number 4. After field verification, Commander, response number 4 prepared a list of affected persons, and the same was forwarded to the district administration Kamrup Metro for approval. Postal. In the report consisting of the list of affected persons, comma, the petitioner was shown to be eligible to receive Zirat compensation for 162 number of rubber trees of medium growth. Para. When after field verification and completion of the report as regards assessment of Zirat compensation, the compensation amounts were not released to the affected persons, comma, some of the affected persons approached this court by UFA writ petition, comma, WPC number 283/2014. Post of the, you were one of them? No.
No, my lord. My lord, earlier this, my lord, 2014 writ petition, there was another writ petition, man. I have annexed in my writ petition. The order at page 20,
Okay.
1787 of 2013 writ petition.
At page?
Page 2020.
Okay. Okay. Some of the UFA writ petition, WPC number 1787/2013. Post of. with a grievance that despite deposit of the compensation amount by the railway administration, the affected persons were not released. Zirat compensation amounts as per the Zirat list prepared in the month of December 2010. After hearing the parties, the writ petition was disposed of by an order dated 3/5/2013 with a direction to the Collector Kamrup Metro to verify whether any compensation would be payable to the petitioners, and upon such verification, if it was found that the petitioners were entitled to any compensation in respect of the Jirat or in respect of the land or both, the same shall be released within a period of 2 months from the date of production of a certified copy of the order by any of the petitioners before the collector. Full stop. Some of the affected persons had again approached this court by a subsequent writ petition, WPC number 283/2024. With an apprehension of eviction without following due procedure. Apprehension of eviction from the acquired land without following due procedure. Full stop. As it was conveyed before the court that no steps were taken, as on date, to evict the petitioners from their lands, the writ petition was disposed of by an order on 28/2014 with a direction to the respondents to carry out the direction already made in the order dated 3/5/2023 in WPC number 1787/2013. Full stop. Para. The petitioner was served with a notice thereafter by the additional by the Office of the Deputy Commissioner, Kamrup Metro, in connection with LA case number 10/2010, whereby the petitioner was informed that an area of land measuring 2 bighas, 2 kathas, 14 lesas under DUG number 41 and annual pattern number 17 at village Moragdula Nonke had been acquired under section 6(1) of the Act. So the petitioner for construction of the railway line, busy railway line from Tetelia to Bonihat. So the petition was directed to appear before in the office along with relevant documents as indemnity bond, bank passbook, photos, etc. to receive land or and/or Zirat, land/Zirat compensation which has been assessed for disbursement in his favor. First of it is the case of the petitioner that pursuant to the notice, the petitioner received, after much delay, an amount of rupees, a sum of rupees 5 lakh 53,600 at A at the return at rupees 325 per rubber tree. Post of 52,065, 650, 52,650. Petitioner did not receive any compensation for acquisition of the land, as the land acquired was government land. Post of. It is the grievance of the petitioner that the acquiring authority had assessed Zirat compensation in respect of 162 number of rubber trees at a much later value than the actual value. So, according to the petitioner, each of the rubber tree ought to have been, the Zirat compensation in respect of each of the rubber tree ought to have been estimated at rupees 13,810 in support of such contention, the petitioner has annexed a certificate dated 8/4/2016 issued under the hand of the Deputy Rubber Production Commissioner, Rubber Board. Post of. As per the certificate, the development cost of a rubber tree and in the certificate, the development cost of a rubber tree, expected income. No, in the certificate, a total amount of rupees 13,810 has been assessed by assessing the development cost of a rubber tree within bracket 2,310, expected income during its 20 years of taping lifespan within bracket rupees 10,000, and cost of rubber wood within bracket 1,500. Full stop. Para. From the facts projected, comma, it is evident that the acquiring of authority, the collector, Kamrup Metro District, as the land acquisition officer, had passed an award of rupees 52,650 in LA case number 10/2010 in respect of 162 number of rubber trees towards Zirat compensation, and the said amount was deposited in the bank account of the petitioner. Full stop. As per the as per Section 6 of the Act, when the collector makes an award under Section 11 of the Act, he may take possession of the land, which shall thereupon vest absolutely in the government, free from all encumbrances. Full stop. Para. Section 18. Part 3 of the Act was titled, quote unquote, reference to court and procedure thereon. Full stop. As per Section 18, quote unquote, reference to court, which was contained in Part 3, as per subsection 1 of Section 18, reference to court. Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the court, where his objection be to the measurement of the land, the amount of the compensation, the persons to whom it is payable, or the required that the matter be referred by the collector. Subsection 2 of Section 18 contain the prescription, had delineated the manner in which such an application was to be made. The application shall have to state the grounds on which objection to the award was taken. Provided that every such application shall be made, A. Aru B.
That's one.
But in the case of the petitioner, it is not the case of the petitioner that after the award was made by the collector under Section 11 of the Act, the petitioner had made any objection in writing by way of an application to the collector within a time period prescribed in Section 18 of the Act. Postal. The petitioner had received, is found to have received the assessed Jirat compensation amount of rupees 52,650 without any objection, and no application was made before the collector objecting to the amount of Jirat compensation so assessed in writing. Full stop. Para. In the affidavit in opposition filed by the respondent number 2, it is averred that the compensation for Jirat standing over the government land had been paid to the encroachers of government land, and those encroachers of the government land were not paid any land compensation as they were not entitled. Full stop. As regards assessment of Jirat in respect of a rubber plant, the collector was shown to have referred to the compensation rate for rubber plants assessed, calculated and approved by the government of Tripura. Adopted. Was shown to have adopted. Which is a rubber plantation growing state. Full stop. After receiving the collector had called for the approved rates approved by the government of Tripura in respect of rubber plants and the approved rates and the rates approved by the government of Tripura in for rubber plantation with regard to age stroke year of a rubber tree had been adopted by the collector for assessment of Jirat in respect of rubber trees by an order dated 15/7/2011. Post op. As per the order dated 15/7/2011, a rubber tree of age within bracket year 6-7 years for a rubber tree. The amount assessed towards Jirat was rupees 325. Full stop. As per the report, in the plot of land acquired vis-a-vis the petitioner, there were 162 number of rubber trees within bracket medium, and it was by adopting a rate of 325 per rubber tree, the amount of Jirat compensation was assessed at 52,250 postal, which no written application filed by the petitioner within the period prescribed in section 30 of the Act objecting to the award assessed was Jirat completion at rupees 52,250 and acceptance of the said amount without any protest, dress code,
But my lord,
fines,
one thing, my lord,
no cause of this court finds that the petitioner cannot thereafter by changing its stand can seek enhancement of the Jirat compensation amount. As in view of the same, in view of the above discussion and for the reasons assigned therein, this petition is found to be bereft of any merit, and the same is liable to be dismissed. It is accordingly dismissed. There shall, however, be no order as to process.
one thing, my the protest part that is mentioned in the bond, my lord. The petitioner received the compensation with protest, my lord.
This petition
That is,
was pending since 2016. There is no averment.
Whether he is.
We don't, you have enough time, 10 years. No,
my lord,
we go by only,
petitioner may allow.
we
to
go by
for a
the
reference, my
pleadings. In read petition, we go by the pleadings. We do not go by the submission made in the way of improvement
Testing part.
during the course of
every-
submission.
Everything is kept in the record, my lord. That is lying in the office of the land acquisition branch.
So this petition is lacking merit.
Only with the observation, my lord, the petitioner.
No, I am not
to
opening
go for
anything.
the reference, my lord.
You go for appeal.
Item 3.
I am not opening anything. For last 10 years, this is the position in the writ petition.
Although, my lord, the value is so less, my lord, 325, my lord. Against part 3, it is so less. Obliged, my lord.
May I praise your lordship? May I pray for adjournment for the time being? Learned senior counsel Mr. A.R. Bhuyan will appear, my lord.
Yes,
In this case, for the petition of learned senior counsel Mr. A.R. Bhuyan will appear. He is on lag in another, after some time, my lord.
it will go after, not after some time, after other matters. Yes, next.
Item 4.
Well, the date may be fixed, my lord.
No, he is seeking time for
Oh.
the time being.
Timing.
But other matters are to be called thereafter, time permits. Yes, sir.
Last order में kindly vision. Last order on our court.
Okay, just a minute then. See, so yeah. Yeah, I have, yeah, about. Further, when time to submit instruction as directed by this court by order dated 24. 2006. Yes, by the last order, what? Submit instruction.
Lordship, GMC was directed to file an affidavit. We've received the signed copy this morning, Lordship. Some of the annexures are incomplete, Lordship. Some time may be given, we'll file it.
You are filing it today.
Lordship will need some time. Some of the annexures are missing.
In this way, the GMC is taking enough time.
Lordship, I have the signed
Enough time
copy.
they have taken.
What is the case about?
Kindly see the last order, my lord.
So I have seen.
My lord.
What
So,
is the case about?
my lord, they have the respondent.
Just let me read.
Simple case is it, my lord.
Just a minute, then I'll ask. The petitioner filed a complaint before the respondent number 2. So this is regarding unauthorized
Unauthorized
construction
construction.
of respondent number 3.
My lord. And now, lordship, the law officer, their law officer at page 51. My lord, 51 make an division. Fifty-two, my lord, last para. 52. That, in my opinion, GMC may proceed to demolish the building after conducting proper inquiry, verification of the land building in case if it is found to be a constructed by not.
Ultimately, it is the commissioner who has to take the call. It is law officer. Ultimately, it is the commissioner who has to take the call.
Lordship, can see
In
page.
the note sheets, many things may be said.
No, no,
Ultimately, it is a
no,
decision.
No, it is true, but unauthorized construction, they have admitted in GMC.
No, they have filed affidavit? No.
Lordship, we were supposed to file it. We've just received the signed copy today.
Okay, you need you have the annexers are not available.
Lordship.
Okay, let them file and annexers are not available. How many? 2
Same
days?
copy, Lordship.
2 days time?
Lordship.
2 days time?
Hey, Lordship, on the last occasion, so that said that today evening they will file the PDP. Now, Lordship, kindly she taking the advantage of the GMC that the GMC should be prompt. I have brought the judgment of the GMC of the High Court that the GMC, when the permission is not granted, GMC themselves came to the court and the court directed GMC to demolish it. That they
Let us have this affidavit. It will be important.
Let
Before
it file, my lord. That will be fixed, my lord, within a week, my lord. But because
heard Mr. R.C. Shoikia, Learned Senior Counsel, listed by Mr. for the petitioner, which for Miss A. Bortakur, Learned Counsel on behalf of
P. Nayak.
Mr. P. Nayak, Learned Standing Counsel, GMC for the response number 1 and 2, and who is for 3?
I am for 3, Lordship.
And Mr.
S.A. Singh, Lordship.
S.A. Singh, Learned Counsel for the response number 3. They have filed an affidavit. Mr. Shoikia, response number 3?
Yes, Lordship.
file an affidavit.
Okay, they have annexed any permission?
No, no permission. They have admitted that there is no permission. And GMC issued notice already that you demolish your building. And that
Miss
notice-
Bortakur
Yes.
has submitted that the affidavit is ready for filing as is ready for filing as the respondent number 2 has already sworn the affidavit.
Lordship.
Today's date is there.
Yes, Lordship. I
Okay.
have copy.
As some of the annexers to the affidavit are to be collected, Ms. Bortakur has sought for a week's time to file the same. Poster. The affidavit, the price allowed, the affidavit is to be filed invariably on or before 1st of June 2026, leaves the case on 4/6/2026.
Lord, and may I pray on that day, my lord, admission that case may be.
They are filing, they are filing.
And offense may be made, my lord.
They are filing.
May be made. Because last time also the court asked them without fail.
That is why I have given you a hearing date.
That is why I am pleased, my lord. Just
No, I will not like to observe for obvious reason.
If they fail.
Sir,
case
I have
filed.
fixed the day. I have given the deadline.
My lord.
Highly obliged.
Item 5.
Yes.
Lordship, this case pertains to freezing of my bank account for a transaction in page number 20 of my writ petitions. Annexure 2,
Yes, which transaction?
transaction dated 4th April 2024 of 62,603 rupees.
4th April or 4th September?
4th September, sorry. 4th September 2024, 62,003 rupees. 603 rupees.
Your Balaji Enterprise or what?
I had the money was transferred from Balaji Enterprise. So, Your Honor, my account was blocked because of this transaction, but eventually in page number 32 of the writ petition, I have returned the amount to the person concerned, and I had also informed the concerned cyber cell also regarding the said amount.
এটা কথা মেনশন কৰিছে লগাইছে 15,000
Where you are holding that account, maintaining that account?
Tinsukia.
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 Tinsukia branch.
This one, please. My lord, I am appearing from the bank.
Yes.
My lord, I am appearing from the respondent number 5 bank. My lord, as per the petitioner, there are disputed transaction one and transaction that is 4924 62,603. But my affidavit in opposition I mentioned in page 33.
There are other.
There are 3 transactions total, my lord. From 3 different police stations, we got this information and we have marked the debit freeze there.
So far as this case is concerned, it has been, the police has said, leave the lien. So far, this
One, yes,
Yes, this case is concerned, you leave the lien. But there are other cases, cyber complaints from Telangana, Tamil
Chennai
Nadu.
North.
Your Honor, the transaction is same. This,
I don't know.
I have returned the amount.
That
also.
I don't know what.
Your Honor, at this
How
point.
can it be? Because this 1 minute. We have received a bunch, right? Also from Cybercrime Police Station, Tirupur City.
Correct.
Though it is not the proper way, but we have received a bunch. They have sent it by post. Right? So I have read this from the reading of the IO. He also says that debit freeze was made in respect of this by Tirupur City Cybercrime Police Station. 27 before that, June 15, something. Then on 27/12/2024, the advocate representing the petitioner appeared at their police station and stated that his client was also a victim of a separate cybercrime. That is a different investigation. He claimed the amount credited to the account was fraudulently transferred in the name of so-and-so. Upon verification, it was confirmed that the account holder was willing to refund the amount, 62,603, to the original victim. The amount was successfully refunded via UPI. Following this, on the same day, 27/12/2024, an official request to unfreeze the above-mentioned IndusInd Bank account without marking lien was sent from our official email ID to the nodal officer of IndusInd Bank. So the issue you have raised with Tirupur City, it is done away with. It is complete. Now he says, subsequently on 31/5/2025, we received a response from IndusInd Bank nodal officer that said the bank account is also linked to another complaint, a cybercrime police station, North Zone, Tondiarpet, Chennai. And CRP acknowledged the number so-and-so involving the same amount of rupees, 62,603. Then he checked the portal. He found that 3 more complaints are there, different states, Assam, Telangana, Tamil Nadu. Now, what is your affidavit in opposition?
In my affidavit in opposition, my lord, I have annexed it at Annexure 1, page 39, my lord. Annexure 1 is with regard to the Tamil Nadu Tirupur City Police Station.
39.
Page 39, my lord. Annexure.
This is the Tirupur City one. Okay.
Yes, my lord. The transaction is shown in the serial number 4.
Just a minute.
1, 2, 3, 4.
Transaction. That is on 14/10.
4/9. Dates are all 4/9/24. And 14/10 is the
Complaint 60.
complaint was lodged.
Where is that Yashu Sharma mentioned? That is that one.
Yes, my lord.
Disputed.
The amount is mentioned, transaction amount 62,603 disputed. This is the number one.
All are disputed.
Yes, ma'am. Then
This is a bank account statement of the petitioner or Sudarshan? This is Sudarshan.
Sudarshan, my lord. The person who has
So all
lost the
these
complaint.
amounts were going out. Or what? This is of Sudarshan.
Not mine.
Yes,
Or
but
petitioner.
Sudarshan has lost the complaint that his account has been.
Right. This page 39. If you go to the second row, it is Sudarshan.
My lord.
Sudarshan's account.
Sudarshan's account. He has lost the
From
complaint.
this account, this amount went out.
Yes, my lord.
Okay.
Then again at page 42, my lord. That is Tamil Nadu CCW SP1 Chennai North.
This is Senthil Kumar.
Yes, my lord. Senthil Kumar, and the police station is Tamil Nadu Chennai
Which
North.
is the serial number?
Here, my lord, serial number is page 44.
Police station.
Police station Tamil Nadu.
Chennai North.
Chennai
or
North.
What? Chennai North or what?
It's Chennai North, my lord.
North.
And complaint addition information is here, my lord, the victim referred by my ex-colleague into crime online demat account, which was running by scammers, and victim has been forced to invest amount in IPO subscription so and so. Go my Mirai asset scammers block demat account.
Suspect mobile, suspect mobile. Okay, now which is the transaction?
And it is page 44, serial number 17. Account credit to IndusInd Bank. Transacted amount is 62,603, disputed 62,603. And third one is in the my lord, it's page 45.
Meaning it was when his account was put on hold, that date.
And is on 14 October 2024, we lost the first received the complaint.
So on the very
Subsequently, we
day,
have
on the very day you have
freezed the
done.
account. We marked
That,
debit.
now page you say 44. This was a transaction of 1810. 1810.
No, 49. 4924.
Page 44.
Yes, my lord. At 12 p.m. Complaint was lodged on 1810.
And any other?
And next is the page number 45. Third one.
45.
It is Mahesh Kumar Namapalli is the complainant. And police station is the Telangana Cyberabad cybercrime. Here the amount is in the very serial number 1, my lord, at the bottom. The same page, 45. 62.
So you have the information, though you have put it in freeze condition.
My lord.
But there are 3 transactions of 62,603 were credited in the bank account of a petitioner.
Yes, my lord.
3.
Three transactions, sir.
3 transactions.
Out of which one has returned,
Ha.
is returned, my lord.
And which is we are concerned with here.
We have received this letter from the police station. Also, we are
No,
annexed here.
no, in this writ petition, we are concerned with this Thirubad or whatever. This is Tirupur.
Tirupur city, Tamil Nadu.
Tirupur city, Tamil Nadu. They have said they have lifted the lien.
Yes, my lord. We annexed the annexure to my lord.
Ha.
This letter.
They have said they have lifted the lien.
My,
Now the other parties you have to make.
my submission, Your Honor, already the cyber cell which I was concerned, they've already stated that I was also a victim of it. Now,
That is a different issue.
now at this point,
A victim
yes,
can also be the perpetrator. There is no law that a victim cannot be the perpetrator. We don't know. We are not accusing you.
Yes.
But question is the issue you have raised in this writ petition has been mitigated. Tirupur has lifted the lien. If you want to have the writ petition regarding other issues, because you have other 2 complaints. Now, in your account, other than this 62,603, which you have returned
yes,
to Mr.
Sudarshan.
The Tirupur had lifted the ban.
yes,
But there still remains 2, right? 2 more persons.
yes.
Mahesh Kumar or something. And Senthil Kumar.
And my lord, for
And
this
Mahesh
two
Kumar
only.
Nampalli.
Yes, my lord. For these
Those
two.
are still in your account.
Your Honor, if Your Honor allows, I may be allowed to execute a bond and undertaking. with the bank.
No. You have to first, like you have made the party here, you have to approach that bank, or sorry, police station. How can it be? Otherwise, this is without jurisdiction. We are trying to, because it is cybercrime, we are entertaining it.
Amendment.
And you have made this Tirupur only.
Yes, party.
And so he has said, he has lifted the ban. So no cause of refunds for you to continue with the writ petition, so far as this writ petition is concerned. So I am closing this. It is up to you. If you have other agreements, you make them this party,
You know,
this Senthil Kumar, whatever.
You know, I can, if your court allows, I can.
No,
the
that
cost
is the
settle-
question of allowing is not there.
Post that.
No.
Of them is part,
Mr. How many years of practice you have put in, sir?
no, new.
My lord, we cannot leave the fridge also here because of one account is open.
No,
also.
that is two other fees.
Because two other are still under
But so far,
investigation.
so far issue raised in this petition, that has been
That-
closed.
yes,
There is already
That has been cleared by the police station.
lien order. Leave the lien order.
My lord.
Then we will only observe that. But so far as there are other freezing order,
That will continue.
that will continue unless he takes resort to appropriate remedy. Heard, Mr.
G. Kaushik.
G. Kaushik, learned counsel for the petitioner. Miss M. Warmont, learned junior Assam for the response number 1 and 2. Mr.
A.K. Gogoi
A.K. Gogoi,
for respondent number 5.
learned counsel for the response number 5. Full stop. Para. The petitioner had approached the court by the instant writ petition. We take revenge that a bank account, savings bank account or current account?
Savings bank.
A savings bank account number 1000 474 96263 maintained by the petitioner at Tinshukia branch of IndusInd Bank, within bracket the response of 5, was kept on hold due to a suspicious transaction dated 4/9/2024 in the form of credit of an amount of rupees, of a sum of rupees 62,603. Full stop. On enquiry with the when enquiry, the petitioner came to know that his bank account was kept freezed due to where is it, Tirupur? Where have you mentioned?
Well, I have mentioned in my affidavit in opposition at page 34.
He has not mentioned. Why? How he can make this officer in charge a party?
But he has
Without
mentioned, he has
any
mentioned,
I
planning?
mentioned.
Where?
well, at page 12, page 12, 13.
Equal line to came to know that the freezing order was passed pursuant to a cyber complaint lodged by one Sri Sudarshan before the Cyber Crime Police Station, Tirupur City, Tamil Nadu. Full stop. Where I communication made. No, full stop. Where have you stated that you are paid? You are paid back
No, same para, he is in the sixth line,
para
13,
Paragraph 13.
and
6th, 7th, 8th line.
1, 2, 3.
having learned about the same, the petitioner informed the Inspector of Police, Cybercrime Police Station, Tirupur City, Tamil Nadu, that a sum of rupees 62,603 had already been returned to the complainant, that is Sudarshan, and requested the Inspector of Police to defreeze his bank account as the disputed amount had already been returned back. Full stop. Para, so with a grievance that despite the return of the amount, the bank account of the petitioner was not defreezed. The petitioner had approached this court by the writ petition with seeking a direction to the respondents, more particularly, the respondent number 3, 4, and 5, to withdraw the order of defreezing. Post of a communication has been received from the Inspector of Police, Cybercrime Police Station, Tirupur City, Tamil Nadu. Oh, it is available. The case record. Post of from the said communication. In the said communication, the Inspector of Police, Cybercrime Police Station, Tirupur City, Tamil Nadu, has mentioned that as the amount was refunded by the petitioner to the bank account of the victim, Sudarshan, via UPI, an instruction was placed by the Cybercrime Police Station. An official request was made from the Cybercrime Police Station on 27/12/2024 to the nodal officer of the respondent, nodal officer of the IndusInd Bank to unfreeze the bank account of the petitioner. Full stop. Para. The above fact is also endorsed by the respondent 5 bank in its counter affidavit. Full stop. Para. From the communication dated 31/5/2025, from the communication dated 31/5/2025 of the Inspector of Police, Cybercrime Police Station, Tirupur City, Tamil Nadu, and the counter affidavit of the respondent number 5, it is noticed that other than the disputed amount of rupees 62,603 which originated from the which originated from the complaint lodged by Mr. Sudarshan, there are other complaints registered in the NCRP, National, what is that? National full form?
Cybercrime Reporting Portal.
National Cybercrime Reporting Portal. Post of the respondent 5 in his affidavit has mentioned about 2 disputed transactions in the form of credit for amount of rupees 62,603 each. Which occurred on 4/9/2024. Full stop. The said 2 disputed transactions whereby rupees 62,603 was credited twice in the bank account of the petitioner and the same were reported. Same have been reported as internet banking related fraud by the NCRP. Full stop. The said 2 amounts of rupees 62,603 each were in connection with complaints lodged by one Senthil Kumar Z and one Mohesh Kumar Nampal. Senthil Kumar G at Chennai North NCRP and one Sri Mohesh Kumar Nampali at Telangana cyber crime. Full stop. The respondent bank has stated that it is though the lien over the bank account of the petitioner or put on the bank account of the petition pursuant to in connection with the instruction received from Cybercrime Police Station, Tirupur City, Tamil Nadu, was lifted on receipt of the request from the said police station. The bank account of the petitioner is still kept on hold due to the other 2 complaints.
But we were not able
related
to lift it. We could not lift it because of the pending 2 complaints.
Due to the other 2 internet banking related fraud complaints. Full stop. Para. As this petition was preferred with regard to the freezing order made on the bank account of the petitioner pursuant to the instruction placed by Tirupur Cybercrime Police Station, Tirupur City, Tamil Nadu, and which freezing order has already been withdrawn by the Cybercrime Police Station, Tirupur City, Tamil Nadu, with an official request to the respondent of 5 bank, comma, there is no further cause of action to proceed. There is no surviving cause of action to proceed further with the writ petition. The writ petition is according closed. If the petitioner has any other grievance with regard to the freezing orders placed on the bank account of the petitioner pursuant to the complaints indicated above, the petitioner it is open for the petitioner to seek appropriate remedy permissible under the law. The instruction placed by Ms. Borman the letter memo number so and so dated 9/5/2025 of the Office of Commissioner of Police, Gauhati, comma, placed by Ms. Borman and Junior Government Advocate, comma, is to be kept with the case record.
Lies.
With respect of item 1, my lord, that I could not call for the affidavit earlier,
my
may
lord.
be taken on record.
ঈদৰ কাৰণে নাথাকে বুলি কৈছে যে এই আমাৰ চৌধুৰীটো ইনষ্ট্ৰাকশ্যন আহিলে নে
27.
সুধি লওঁ গভৰ্ণমেণ্ট এডভোকেট আছে নে নাই মই এজন কৰি দিব লাগিব
Supplementary list. Item number 27.
Ms. Bhawan, have you received any instructions?
Lordship. There you go.
Somehow.
Last para, my lord.
Yeah. Mr. Chaudhary has submitted that he would not be available.
Lordship. Last occasion it was mentioned, my lord. On last order, I have seen, my lord, it was mentioned.
First of June, the Okay.
Lordship disposes of, then I can provide this instruction to Mr. Chaudhary personally, my lord. That can be done.
Yes. Anybody for age market, okay. This writ petition. was preferred. With an allegation that, with allegation, no, that would be, was preferred on the ground that the petitioner filed a complaint petition before the learned Chief Judicial Magistrate, Aila Kandi, against a number of the accused persons from a name Derry, alleging commission of offences under sections 120B, 468, 420, 506, 294, 34, Indian Penal Code. The said complaint was registered as CR case number 1214/2023 and was transferred to the Court of Learned Judicial Magistrate First Class, Hailakandi, for disposal. Para. By an order dated 7/2024, 25. By an order dated 27/10/2023. The Court of Learned Judicial Magistrate First Class, Hailakandi, JMFC Court of Law, forwarded the complaint to the respondent number 4. That is the officer in charge, Ramnathpur Police Station, to register an FIR and to cause investigation. Post up. So, by the order dated 27/10/2023, the complaint petition was forwarded. The respondent number 4, but the respondent number 4 did not register any FIR, not to speak of initiation of any investigation. Post stop. The petitioner had once again filed a complaint case, CR case number 563/2024 before the Court of Learned Chief Judicial Magistrate Hailakandi on 27/5/2024. Full stop. On receipt of the complaint case, CR case number 563/2024, the JMFC called for a report again from the respondent number 5 and dispose of a report again. Full stop. After receipt of a report from Ramnathpur Police Station, report dated 6/2/2025 from Ramnathpur Police Station stating that from the respondent report stating that he did not find any record of CR case number 1214/2023 at Ramnathpur Police Station. The JMFC, Hailakandi, passed an order on 7/2025 taking a serious view on the matter and expressing dissatisfaction, directed the respondent number 4 to immediately register the FIR on the basis of the complaint case, CR case number 1214/2023, and to investigate into the matter and to submit a report in final form. Full stop. The respondent number 3 was directed to take stern action against the erring police officials for refusing to register the FIR in spite of the complaint disclosing commission of a cognizable offense. Full stop. A copy of the order dated 7/3/2025, whereby the direction was made in complaint case number 1214/2023, while disposing of CR case number 563/2024, was forwarded to the respondent number 2 for information. Post of para when, despite the direction made in the order dated 7/3/2025, passed in CR case number 563/2024, the respondent number 4 did not register any FIR. The petitioner had approached this court by the present petition seeking inter alia direction to the respondent authorities to register the FIR on the basis of the complaint case from CR case number 1214/2023 in terms of the order dated 7/3/2025 passed by the Court of Planet JMFC, Hailakandi. Post of para when the petition was moved, on 5/9/2025. The respondents were put on notice. Post of para Miss M. Borman, learned junior government advocate, appearing for the state respondents, has placed an office letter bearing memo number 25/5/2026 of the Senior Superintendent of Police, Hailakandi, addressed to the Junior Government Advocate Assam, Gauhati High Court, and has submitted that based on a complaint lodged by the petitioner. Based on the complaint case number 1214/2023 lodged by the petitioner. The case has been registered right Ramnathpur as case has been registered as Ramnathpur Police Station case number 26/2026 under sections 120B, 468, 420, 506, 294 IPC read with section 34 IPC. First of it is stated by the Senior Superintendent of Police, Hailakandi, that investigation of the case has already commenced. Post of para. As based on the complaint case number 1214/2023 and the subsequent complaint case, CR case number 563/2024. A case has already been registered as so-and-so police station under section so-and-so. An investigation has been initiated and the investigation is in progress, the grievance raised by the petitioner in this writ petition is found to have been redressed. Post of in that view of the matter, the writ petition is disposed of. Post of if the petitioner feels himself aggrieved in the manner of investigation of Ramnathpur Police Station so-and-so, the petitioner recourse is available to the petitioner to seek appropriate remedy under the law. So before that, on the last date of listing of the case on 22/5/2026, the Land Council for the petitioner had apprised this court that he would not be available today. Post of as the grievance raised by the petitioner has been appropriately redressed, this order has been passed, taking into account the submission made by the Land Council for the parties as regards its non-availability today.
Problem.
Daily list, item number 6.
May I please, Your Lordship? My Lord, I'm sorry I'm appearing through VC, my Lord.
Lordship, we have been directed to obtain the instructions. May I pray a little accommodation, 1 or 2 days accommodation, Lordship? As because, Lordship, I have contacted the office of the District Commissioner Tinsukia. They have stated that they have sent the instructions, but most probably it is somehow misplaced in our office. But they are again sending us to me. So only 1 or 2 days accommodation, Lordship.
Yes, Mr. Pukon.
My Lord, may I draw Your Lordship's attention to the 10th March order?
Yes, Lordship, that order.
They are saying that the instructions have been, have you heard, Mr. Sharma?
I heard, my Lord.
That it is at the
Only 1 or 2
it
days
is at the
accommodation.
office of the government advocate. They have misplaced the instruction.
My Lord, my Lord. My lord, no difficulty. My lord may grant them.
Let us put it on Monday or Wednesday.
Lordship, any date as per Lordship.
Next
Because they
Tuesday,
are
next
sending it
Tuesday.
by today itself.
Next Tuesday, because Thursday is holiday.
My lord.
Okay. Heard Mr. A. Fukon, Learned Counsel, for the petition through the partial mode. Which Mr. For P. Sharma, Learned, through the partial mode, with Mr. P. Sharma, Learned Counsel for the petitioner. And Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 1, 2, and 3. So, Mr. Sharma, Learned Additional Senior Government Advocate, has submitted that the instructions
That may not be reflected. Only one or two
are
days.
sought for
Lordship.
a short accommodation to enable him to place proper instruction before the court. Also, as sought for by Mr. Sharma and as agreed to by the Learned Counsel for the petitioner, release the case on next Tuesday.
2nd June, 0206.
Lordship. I will positively place it.
2nd of June.
Obliged, my lord, deeply obliged.
Item number 7 to 10.
Yes, what are the affidavits?
Lordship, affidavits, the minutes have been placed, Lordship, on record. Minutes have been placed on record.
Not yet available.
Oh.
Ready to. In judgment.
With item number 9, the minutes have been placed on record. The rest of them are replies on merits, Lordship.
Where is Sir Roy?
Breaks, my
Okay.
affidavits are not.
Because we are taking a 4 repetition, let us have the facts.
Yes, sir.
It may so happen that we may not complete today,
Yes.
but we'll keep it part heard. Because if facts go wrong, it will be difficult
Yes.
for me to correct 4 repetitions.
Morning it was possible.
7, 8, and 9, Lordship. 10 was previously.
No, I need my concentration. All are 302. Where is your that some you have placed document earlier?
Lordship, I placed a chart.
এখন বনাইছিল না নোট নোট এখন বনাইছিল না ক'ৰবাত চাওকচোন ক'ত আছে চাই লওক
Lordship, also on the last occasion, Lordship had inquired whether there are certain other provisions pertaining to remission. So I've checked it up. There are certain rules that I will place, Lordship, after.
So let us place the facts
Yes.
first.
Yes. Should we take up the first?
Nine. Okay, the entire minutes was there, we to detail. Not one, I put the server. All these four petitions.
Here is the minute, entire minute is there.
Yes. Is it part of the affidavit?
Entire was not there.
Let us have then.
Hmm. Whereby item number 7, 8, and 9 has been considered. Petitioner of item number 7, 8, and 9.
On that entire minute.
Yes.
What is the petition number? What is the
Serial
name of
number
the-
is Lordship
Huh.
20, 21, and 75.
20,
21 and 70.
20.
20, 20.
Moinuddin.
Moinuddin. 21 is Samshul Mia.
21 Samsul Mia.
And 75. Last. They were considered in this minutes. 22, 7, 24 minutes.
$75.
5.
And what is the judgment, Sangit?
Lordship, this was followed, Lordship. This was my instruction, which they followed while considering this minutes. There is 19.3. 26 minute is also there, Lordship. Whereby item number 11 has been considered.
Let us have the facts first.
Lordship.
All these four writ petitions. Under Article 226 of the Constitution of India have been instituted by four convicts separately, who are undergoing a sentence of life imprisonment. For commission of offenses punishable, inter alia, under section 302 of the Indian Penal Code, full stop. By presenting these writ petitions, the petitioners
have sought for issuance, have assailed decisions taken by the state level review board comma two meeting, one is 22/7/2024, the other one
is
19/6.
19/3/26.
Okay. In its meetings held on
2026.
in respect of the petitioner in item number 11, WPC number 11, 11, the 10, 10. And on 22/7/2024, in respect of the petitioners in 7, 8, and 9. Yes. First off, by the decisions taken, decisions taken, the state level review board has rejected the prayer of the petitioners for their premature release, CRPC, under section 432, Code of Criminal Procedure, 1973. The code or
If I may just point out one aspect. In respect of item 10, the minutes are not under challenge because it was a case of non-consideration. In the pendency of the writ petition, we were informed of the minutes.
আসলে অকল সেইটো দিলে হ'ল প্ৰথমটো দিব নালাগে item number 10 বুলি in a meeting held on 22/7/2024 in respect of the petitioners in 6, 7, 8 and 9. First of দহটো চাওঁ দহটো নামটো কি আছিল হলিৰাম হলিৰামটো ক'ত আছে এইটো হলিৰাম তেনে অলপ মিলাব লাগিব 22/7 on a sort under 236 of the Constitution of India, agreed by the decisions taken by the state level review board as regards their prayers for premature release in terms of section 432 CRPC. Insofar as the petitioners in 6, 7, 8 are concerned, the state level security board state level review board in its meeting held on 22/7/2024 has rejected the proposal for the petitioner's release, premature release, full stop.
In deferral of the proposal. Proposals have been deferred, not rejected, Lordship.
22/7, okay.
Yes.
Decision of the state level to defer consideration of the proposals submitted before it for their premature release under section 432 CRPC. First of, insofar the petitioner in WPC number 524, 2026 has sought for a direction to the respondents to consider his case for remission and premature release on the basis of a proposal dated 11/4/2025, prepared by the Superintendent Special Jail, Morrigaon, Portfit, Post-op. During the pendency of the petition, it is submitted that what has happened to his case?
Item number 11.
10.
Item number 10, his case was thereafter considered on 19/3.
During the pendency of the petition, the case of the petitioner was considered by the State Legal Security Board on 19/3/2026. And the State Level Security Board, what had happened?
It was rejected and
Has
days before after 2
rejected.
years.
Has rejected his case
Deferred.
for remission. Rejected or deferred?
Deferred, Lordship.
Has deferred his case for remission, which is to be considered after a period of 2
2
years.
years.
Post-op. Before going to the issues raised regarding the decision of the State Level Review Board on behalf of the petitioner, and as controverted by the learned counsel for the respondents, it would be appropriate to refer to the factual matrices involved, factual backgrounds involved in each of the petitions. In brief. Come back. Next one is WBC number.
Before Lordship commences, Lordship, I prepared an updated note with reference to the judgments.
6283. (2025). Two. At about 1 p.m. on 10/6/2001, one boy of 6 years age went out from his house with the petitioner. When the boy did not come back to his house till 7 p.m. on that day, the family members searched for him at different places, but the boy could not be traced out. Post-op. Then, they searched, they charged the petitioner, and in reply, the petitioner told them that he sent the boy somewhere by a bus. But could not mention about the destination. When the petitioner admitted about committing sodomy, a, a, a an FIR was lodged. An investigation was initiated. After completion of investigation, a charge sheet under section 377/302 Indian Penal Code was submitted. First of when the case was committed to the Sessions Court, the petitioner, the charges under section 377 and section 302 of the IPC were framed as the petitioner did not plead guilty, the trial proceeded. After examination of 10 prosecution witnesses and recording of statement of the petition under section 313, the trial court found the petitioner guilty of the charges under section 377 IPC and section 302 IPC. Most of the trial court had reached a finding that the evidence on record led to a safe conclusion that the petitioner committed the offenses of sodomy and murder. Full stop. For the offense under section 377 IPC, the petitioner was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 3,000, with default stipulation. Full stop. For the offense under section 302, IPC, he was sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, with default stipulation. Full stop. Subpara. When an appeal was preferred by the petitioner before the division bench, before the High Court, before this High Court, the criminal appeal, criminal appeal jail, within bracket J, number 105 of 2025 was dismissed by a judgment and order dated 21/3/2011, upholding the conviction of the petitioner on both the charges, thereby confirming the sentence of imprisonment for life. Papera. On completion of about 21 years in custody, comma, the petitioner, extra 5, an extra 5 page. Okay. The petition on 19/5/2023 submitted a petition, an application before the district magistrate Dibrugarh and the superintendent of police Dibrugarh for a conduct report, as he had been incarcerating in jail since 13/1/2001. Full stop. On receipt of the said application to the superintendent of jail, to the superintendent of district jail, Lifu. On receipt of the said application, the superintendent, district jail, Difu, on the same day, wrote to the district magistrate Dibrugarh and superintendent of police Dibrugarh in terms of an office memorandum dated 6/10/2025, enclosing therewith all the relevant documents for a conduct report. Full stop. On 19/5/2023, the superintendent district jail also wrote to the district judge Dibrugarh requesting for an opinion in a matter of premature release of the petitioner. Full stop. The district judge, session judge, Dibrugarh, on 10/7/2023, forwarded his opinion to the effect that he had no objection page
61, Lordship.
opining that there was nothing on record which would bar the appropriate government in to exercise the power under section 432 CRPC or section 433 capital A CRPC. Full stop. It was fined that the descriptive role of the petitioner, as provided by the district jail, depot, was good, and he did not have any objection, if the appropriate government, in its discretion, would exercise its power under 432 CRPC to remit the sentence imposed on the petitioner. Full stop. On 17/7/2024, the superintendent district jail, Difu, forwarded a proposal for release of the petitioner to the Inspector General of Prisons, Assam, with the conduct reports received from the District Commissioner Tinsukia and the Superintendent of Police Tinsukia. Along with the opinion of this session judge Tinsukia and other relevant documents. First of it was reported that the conduct and performance of the petitioner in the jail was found to be good, and petitioner was found to have maintained discipline in the jail sincerely. First of it was reported that the petitioner could now be considered fit for release as and it was reasonably expected to be able to, and he was reasonably expected to resume a useful and law-abiding life after release. Full stop. Subpara. When the proposal of the petitioner was placed before the what does it call? The total name? What is it?
State level review board.
State level review board. The same was considered by the board in its meeting dated 22/7/2024. Full stop. The board resolved to defer consideration on a matter of premature release of the petitioner. The board in its meeting held on 22/7/2024 resolved to defer the matter of the proposal of premature release by a period of 2 years. Is it part of the record?
Lordship.
Or Mr. Roy has submitted something?
Lordship, I have given the minutes. part কে করা আছে is serial number 75.
Full stop. Thereafter, the proposal of premature release was considered by the board, preview board, once again on 22/7/2024. And the board deferred the proposal for 2 years again, right?
Lordship.
Due to the heinous nature of crime, kidnapping and murder of a minor child. Next to কোনটো আছে? Next to কোনটো আছে? শামসুল মিয়া।
Facts are at page 51.
Page
51, Lord.
The petitioner, WPC number 5946. The petitioner was tried in Sessions case number 103/2006 before the Court of Learned Additional Sessions Judge FTC Borpeta. Full stop. The prosecution case in brief was that the petitioner married the daughter of the informant two years earlier to the date of institution of the affair on 27/10/2004. Post up. After the marriage, the petitioner started torturing his wife both physically and mentally on the plea of dowry, and other accused persons also assisted him. Full stop. On the informant, the affair stated that on 25/10/2004, 4. When the informant, that is the father-in-law of the petitioner, went to the house of the petitioner in the wee hours, he found the dead body of his daughter hanging in a jamu tree. When alarm was raised, the petitioner and the other family members of the petitioner fled away from the place. Full stop. The affair was registered as Borpeta Police Station case number 545/2004 under section 304B, capital B, IPC. Full stop. On after submission of a charge sheet, charges. A charge under section 304B IPC read with section 149 IPC was framed against the petitioner along with how many? Along with
Four
one.
others.
Four others.
Four others.
Along with four others. Four other accused persons. During the course of the trial, charge was altered to section 302, 4 and 498A read with section 34. Full stop. At the end of the trial, after the trial, the petitioner
$72.
and 122 Mia were convicted for the offences under section 302, IPC read with section 34 IPC. And other 3 accused persons were acquitted from the charge on the ground that the prosecution could not establish their case beyond all reasonable doubts. Full stop. The petitioner and other accused persons while observing that, the learned trial court, while observing that the case did not fall under the rarest of rare category of cases deserving extreme penalty, the petitioner was sentenced to undergo rigorous imprisonment for 6 months and to pay a fine of rupees 1,000, with default stipulation, for the offence under section 498A IPC. Full stop. For the offence of murder under section 302 IPC, the petitioner was sentenced to undergo imprisonment for rigorous imprisonment for life and to pay a fine of rupees 2,000, with default stipulation. Full stop. The sentences were ordered to run concurrently. Full stop. The other convicted person was directed to undergo imprisonment for life and to pay a fine of rupees 2,000, with a default stipulation. Full stop. Sample. The petitioner and other convict preferred a criminal appeal, criminal appeal number 127/2009 against the judgment and order dated 19/6/2009 of the trial court, whereby they were convicted and sentenced. Full stop. A division bench of this court, after hearing, dismissed the appeal by judgment and order dated
26/7/2013.
26/7/2013,
2013.
finding no merit therein. Full stop. The conviction, the judgment and order of conviction and sentence passed by the trial court was upheld. Full stop. After spending 20 years in incarceration, the petitioner submitted an application on 21/12/2023 seeking his before the Inspector General of Prisons, Assam, through the Superintendent of District Jail, Borpeta, seeking his premature release. Full stop. On receipt of the application, the Superintendent of District Jail, Borpeta, prepared a proposal for release of the petition on remission and communicated the matter to the Inspector General of Prisons on 5/1/2024. Post of the relevant documents pertaining to the petitioner's incarceration, including the descriptive rule, certificate of conduct and behavior, and the judgment of the trial court, etc., were forwarded along with the proposal. Page?
Proposal is at 92.
I 2024. Page 92.
Yes.
What is the opinion of the district judge?
88.
Prior to sending the proposal from the superintendent of District Jail Borpeta also forwarded the matter to the Court of Learned Additional Session Judge FTC Borpeta for his opinion. Who called for a report from the Superintendent of Police Borpeta. First off, on submission on perusal of of a report submitted by the Superintendent of Police Borpeta. After perusal, the Learned Trial Court recorded an opinion that there existed a probability that the crime might not be repeated and no fruitful purpose would be served by keeping the convict in prison. In his order dated 12/12/2023, the additional session judge FTC opined that had recorded his opinion that there existed no hindrance in releasing the convict on remission. Full stop. Stop there. When the proposal of the petitioner was placed before the review board, it came to be considered serial number 21. 21.
21.
21.
That is on record in the other place.
The proposal came to be considered by the review board in its meeting held on 22/07/2024. First off, the review board, however, took a decision to defer the proposal by 2 years, observing that the crime committed by the petitioner as the prime accused was of heinous nature. Full stop. Yes, next to Mohammed Moinuddin. WBC number 5999/2025.
Page 48.
The allegation against the petitioner was that was of committing murder of his nephew, comma, who was 14 years of age, full stop. In the FIR lodged in that connection, comma, it was alleged that at about 4 p.m. on 11/10/2003, comma, the nephew of the petitioner went out from his house on a bicycle and at about 2 p.m. on 12/10/2003, comma, his dead body was found in the midst of reeds, full stop. In the FIR, comma, suspicion was made towards the petitioner and one Asghar Ali. A case was registered for the offences under section 302 stroke 201 stroke 34 IPC. And was investigated. After submission of the charge sheet and securing the appearance of the petitioner and the other accused person, after prolonged delay, comma, charges were framed for the offences under section 302, 201 IPC, read with section 34 IPC. At the end of the trial, the trial court of learned sessions judge, Borpeta, pronounced the verdict of guilt on 26/10/2006. Full stop. The trial court found that both the accused persons, including the petitioner, comma, were guilty of the offences under section 302, 201, 34 IPC. As the prosecution was able to establish the case beyond doubt. Full stop. The petitioner and the other convicts were sentenced to undergo imprisonment for life each and to pay a fine of rupees 2,000 each, comma, with default stipulations under section 302 IPC. Post op. They were also sentenced to undergo rigorous imprisonment for a period of 3 years each and to pay a fine of rupees 500 each. Because the sentences were ordered to run concurrently. Software. Agreed by the judgment and order of conviction and sentence passed against them in Sessions case number 120/2004 by the Trial Court of Learned Sessions Judge Borpeta. The petitioner and the other convict preferred a criminal appeal, criminal appeal number 16/2007 before this court. After hearing a division bench of this court by judgment and order
1/12/2011.
1/12/11
2011.
upheld the verdict of the trial court, thereby affirming the conviction and sentence passed against the petitioner and other convict. It was observed that having regard to the totality of the evidence on record, it had reached an unhesitant opinion that the judgment and order of conviction and sentence did not warrant interference at the appellate stage. Stop there. A representation was submitted by the petitioner before the respondent authorities through the Superintendent of District Jail, Chirang, in the year 2021. Full stop. The Superintendent of District Jail, Chirang, sought conduct reports from the District Commissioner, Chirang, and the Superintendent of Police, Chirang. In response, the Superintendent of Police, Chirang, submitted a contact report on 12/3/2021. Opining inter alia that when the petitioner was granted annual leave on 4 occasions, he did not indulge in any criminal activity and returned to jail in time. Full stop. It was further mentioned that there was no criminal case pending against the petitioner. Full stop. When the Superintendent of District Jail, Chirang, sought an opinion from the trial court, the learned session judge Borpeta, page
74.
considered the case records of Sessions case number 120/2004 and an opinion submitted by and the opinion submitted by the Superintendent District Jail Borpeta. Borpeta or Chirang?
Lordship will be Borpeta.
Borpeta. Where the petitioner was lodged, serving his sentence. In the report, the Superintendent District Jail Borpeta reported that the petitioner was a hardworking, sincere prisoner who used to obey the rules and regulations of the jail, and therefore he was found to be fit to resume life after release as a law-abiding citizen. Full stop. The learned trial court had, however, mentioned that it could not be said whether remission should be given to the petitioner or not. In his order dated 29/5/2021, the trial court had observed that it had nothing to say whether the sentence of life imprisonment imposed upon the petitioner should be commuted or not. Full stop. The District Commissioner Chirang in his report dated 15/9/2021 based on the conduct report submitted by the Superintendent of Police Chirang, observed that there was no criminal case against the petitioner, and the petitioner could be considered for granting remission. Full stop. When the proposal for remission of the petition was forwarded to the review board, the same was placed before the review board. Before consideration of the review board in its meeting held on 22/7/2024. Full stop. The review board deferred the proposal on the ground that the opinion from the trial court was not clear. Paulina.
If in this case, the facts of the case are not available, given that it was only, Lordship will find page.
WPC number 524/2026.
Page 24.
Page?
25, Lordship.
The petitioner stood the trial, stood in a trial of Sessions case number 47 within bracket capital A stroke 1999 for the charges under section 147, 148, 436, 326, 324, 302, 149 IPC. After trial, the trial court of learned Sessions Judge Morigaon by a judgment dated by a judgment and order dated 5/5/2003 held him guilty for the aforementioned charges. First, after hearing the petitioner as the accused on the point of sentence under section 325(2) CRPC, the petitioner was sentenced to death full stop. The petitioner preferred a criminal appeal from jail, which was registered as criminal appeal number 5 within bracket J stroke 2003. So at the same time, the criminal death reference number 02 stroke 2003 was also made. Full stop. A division bench of this court confirmed the judgment and order of conviction and sentence passed by the trial court on 9/3/2004, full stop, para, is against the judgment dated 9/3/2024 of the division bench, comma, an appeal was preferred by the petitioner before the Honorable Supreme Court of India, and the same was registered as criminal appeal number 2432/2004. Post of the Honorable Supreme Court of India upheld the conviction and sentence when
5/7/2004.
5/7 or 8/4. Page 35 is different.
Lordship may have page 63. That is the proposal of the special jail Nagaon. Second paragraph, 6th line from the top.
No, I was looking at the judgment of the
High Court.
High Court also at page 24. At page 35, it says 8/4/2025. Oh, 2005.
8/4/2005.
Which one is correct? On 5/7/2004. First up.
Well, check it up.
Mercy petitions under Article 161 and Article 77 of the Constitution were preferred by the petitioner before the Governor of Assam and the President of India, respectively on 18/4/2005. That is, after dismissal, after 8/4/2005 perhaps. Something is wrong.
Yes, well, just check it up on the website. We will.
এইটো ব্ৰেকেটত বোল্ড কৰি ৰাখিব, যিটোত মই কৈ থৈছিলোঁ যে 5/7/2004, তাতে ব্ৰেকেটত 8/4/2005 ৰাখিব. That is after 10 days. 10 days, that is 10 days after the dismissal of his appeal by the Honorable Supreme Court, through the Superintendent of Police, Jail, Nagaon. Post of subpara. It was subpara after dismissal. The Honorable Governor of Assam rejected the mercy petition of the petition on 26/6/2013. Full stop. The Honorable President of India also rejected the mercy petition on 25/7/2014. After rejection of the mercy petitions, the petitioner preferred an appeal before this court.
Yes, Lordship.
Right.
Page number 24.
A writ petition, by a writ petition, WP within bracket CRL number 05/2014, questioning the legality of the rejection of the mercy petitions filed by him before the Governor, Honorable Governor of Assam and the Honorable President of India. After keeping the mercy petition for more than 9 years without any decision. Full stop. As the petition was facing execution of its sentence passed by the trial court, it is 8/4/2005, by the way, passed by the trial court in Sessions case number 47A of 1999, which was confirmed by the Honorable Supreme Court in its judgment and order dated 8/4/2005.
Lordship, I've checked it up. That is the correct date. 8/4/2005.
8/4/2000. Full stop. By judgment, an order dated 23/12/2015, the division bench had allowed the writ petition commuting the death sentence of the petitioner into imprisonment for life, which would mean imprisonment till the end of his life, subject to any remission granted by the state government under section 432, CRPC, which, in turn, would be subject to the procedural checks mentioned in the provision and further substantive check in section 433A of the code. What is the law? I don't know.
Lordship, 433A is the limit of 40 days.
No.
Yes.
Law is regarding this.
Yes, that remainder. When there is a commutation, whether
Once trial court convicted, death sentence, appellate court affirmed, Supreme Court affirmed, mercy petitions dismissed. Just because it was delayed by 9 years, it has been converted to remainder. The division bench said, now procedural checks. What kind of procedural checks? You have to see Sri Haran or something, constitution bench.
yes.
Full stop. And then what happened? It is
Lordship, there is a request for conduct report. Page 47.
page
47, Lordship. You may have the original at 49.
What is that annexure 4? Can you place this Sonadhar? Do you have any copy of Sonadhar?
Lordship, not today. So another has been crystallized thereafter in a judgment of the.
Anyway,
Yes,
but I need to.
I will place that. Lordship.
A Sonadhar, huh?
Yes.
Versus State of Chhattisgarh. Sonadhar, Sonadhar. State of Chhattisgarh. SLP criminal number 529, 2021, order dated 22/10/2024. It is pertinent to mention that the Honorable Supreme Court in the case titled Sonadhar versus State of Chhattisgarh, page 45 plus, SLP criminal number so and so. On 22/10/2024, directed all concerned to dispose of the pending applications of prisoners and to clear the backlog at all levels within the next 2 months. Full stop. After the said order of the Honorable Supreme Court, the Inspector General of Police asked the superintendents of jails, all across Assam, on 29/10/2024 to accord highest priority to forward the application of premature relief of all the eligible life convicts in their respective jails to him for placing the release proposals before the state level review board. Full stop. Subpara. It was in response to the letter dated 29/10/2024 of the Inspector General of Prisons, Assam, the Superintendent of Special Jail Nagaon requested the District Magistrate Morigaon and the Superintendent of Police Morigaon on 31/10/2024 to submit conduct reports from their ends in case of the petition, in respect of the petitioner. Full stop. In the office letter dated 31/10/2024, the Superintendent of Special Jail traced the case history of the petitioner briefly. First off, in the same letter, it was observed that the petitioner's conduct and behavior with the co-inmates as well as the jail officials was found to be satisfactory, and no adverse report was found during his period of conviction. Full stop. The the Superintendent Special Jail Nagaon. While his office letter dated 2/2/2025 also sought for an opinion for granting remission to the petitioner from the Sessions Judge Morigaon post of. After going through the case record, comma, the session just also considered the report received from the Superintendent's Jail, Nagaon, wherein it was mentioned that the character of the petitioner was satisfactory. An earlier report. And there was nothing adverse against the petitioner. Post op. A report was also received from the district administration. Report dated 22/05/2025 was also received from the district administration, wherein it was reported that it could be reasonably concluded that the release of the petitioner was unlikely to cause any law and order issue in his area of residence. Post op. The session judge also considered a report from the report dated 20/12/2024 of the receipt from the Superintendent of Police Morigaon, wherein it was mentioned that nothing adverse was found against the petitioner. Post op. Based on such reports, the session judge had opined that the petitioner could be released for remission under appropriate provisions of the code. Full stop. Then it was placed.
Yes, Lordship.
A proposal
The proposal
was proposal for release of the petitioner on remission was finally forwarded by the Superintendent Special Jail Nagaon to the Inspector General of Prisons, Assam, on 11/4/2025. Full stop. As when the situation rested in such position, the petition, the instant writ petition is preferred. The petitioner preferred the present writ petition, seeking a direction to the respondent authorities to forthwith consider his case for remission and premature release on the basis of the proposal dated 11/4/2025, post op, during the pendency of the writ petition, as mentioned above, What is that?
Lordship, it was earlier placed on 24/6/25 meeting, Lordship. 24/6/25. That prior to that 22/7 serial number 14 and again in 19/3.
It was the review board considered the proposal of the petitioner in its meeting held on 24/6/2025.
And in 19/3/26 also his name.
And also subsequently on
19/3.
22/7/2020.
No, Lordship, 22/7 his was not.
Okay.
19/3.
19/3/2026.
It
It is part of this
Yes.
bunch.
Yes. 19.3 is prior to that.
Full stop. On 24/6/2025, serial number
14.
the review board had observed that though there was no adverse conduct and behavior in respect of the petitioner during his period of imprisonment, the case should be deferred as the nature of the crime was heinous and his premature relief would be was perceived to be a threat to the society. Full stop. In the it is wholesale dismissal.
In 19.3.
Huh?
Yes. 19.3 was not
in
individual.
its meeting held on 19/3/2026, the review board, sorry, proposals of 32 plus 58, কি হয় তো চাইলেও, proposals of where life convicts were placed before it. And after deliberation, the review board decided to return 32 proposals, 32 plus 57. All.
Only one was considered.
Except one. To the Inspector General of Prisons, Assam, with a direction to resubmit the proposals after proper application of mine in terms of the directions of the Honorable Supreme Court of India. Who is this?
Lordship. It was annexed, Lordship.
That is?
Lordship.
Sangeet versus Haryana. Seems like Sangeet versus
Sangeet, because it was Sangeet
in
and-
criminal appeal number 490-491 of 2011, within bracket, Sangeet and another versus State of Haryana, bracket close, decided on 20/11/2012. Much water has flown.
Yes. Exactly.
Much water has flown.
Yes, yes.
Lordship.
Full stop. What a day. Okay, it's very difficult. Facts are already anything missing? Facts?
No, Lord.
Not on the law.
Yes.
Facts?
Yes, I think it's comprehensive.
Since we are not dealing with the facts or with the law, so Mr. Atreo, you
Yes.
collect the draft of the factual thing, Mr. Roy, on Friday, because Thursday is a holiday. Whatever correction you indicate. This is not part of the record now. Heard Mr. A. Atreo, learned counsel for the petitioners, and Mr. S.S. Roy, learned state counsel for all the respondents. Full stop. You have filed affidavit, right?
In all the cases.
The affidavit in opposition filed on behalf of the state respondents through the respondent number
6.
6.
And IG prison. See, in some in one case, I 7.
The affidavit in opposition filed by the Inspector of Prisons, Assam,
IG prison.
in
All the cases, Lordship.
okay. In the cases are brought on record. Full stop. Heard the learned counsel for the parties. As the hearing is not concluded, release the case says on. It's a division. Huh? Order the division is like that. Lead your interval question. Huh? Go ahead. Due to some process. Tuesday. I think to go down a very close and use it. People don't know him, no matter. It was very on. There was a partner, no? 2/6. 2/6, 2026. The cases will be taken up at 3 p.m.
Obliged.
Partner could do. 2/6. It's from V2 then. Two six, 3 p.m.
Thank you, Levan.
Yes.
This petitioner filed transfer of case from dispute to any other agency lordship.
Oh, yes, Mr.
That case there he was called for and allowed.
Yes, Miss Bormon. I'll have just a glance. Thereafter, you will give me the bullet points. I'll not. Then we'll consider it. First,
First lordship.
he has to go through. I'll just have a glance.
On the portions my love flagging where this statements has been recorded. So far as recovery is concerned, nothing is there in.
That is the main point because the amount is 32, almost 32 crores.
Who is the investigating officer?
It's from dispute PS.
Oh,
Only as per last.
what is your rank?
Rank.
Sub-inspector.
Yes, my lord. And last note, last page,
Is there no?
CD, my lord. Last page, probably he is posted out already, my lord.
Let us see.
Okay. Recovery recommend. Team investigate Coris's thorough news base in the month of January 1st. Basically, last note the 26th of last day. Process करके हाथ स्टाइल he has been posted out. तो by the end. Yes.
This Umang
Umang
Parma,
Parma.
things continued during which period?
During the relevant period when the occurrence, that is from in the FIR also you'll find annexer 1 page 21.
Tell me.
That is from 1st of April 2018 to 6th of January 2025. In the FIR it is there.
Madam,
Lordship.
you are happy with only Umang Parma or what?
Because others are also there because
CD doesn't reflect anything progressive. CD does not reflect anything satisfactory, my lord. I found only 3 days investigation CD recording is there. 18, 19, 20 in the month of
Prepare
January.
a note. He collected details of all the transactions from 2018,
Lordship.
whereby money was siphoned off
Lordship.
to the personal account of Umang Parma. Thereafter, money had been siphoned off to some other entities or individuals. So, Axis Bank had provided the details.
Lordship.
So, you have to tell me fairly what action you had taken after getting all this information.
Lordship. That is not reflected.
You have to give me a
Lordship.
statement after going through what action you have taken.
Lordship.
Initially, what Umar Parmar stated and this informant stated.
Lordship.
Then what kind of investigation is required? Seizure of PAN card, photo identity card, driving license of Umar Parmar is going to help the investigation.
Definitely not, my lord.
This is a money trail.
Representative, they are taking out the transactions, my lord.
Transactions.
Basically on the transaction.
Initially from the, what is that? Company.
IFCO company.
To the personal account of the accused. Thereafter it spread.
Diverted.
Yes, yes.
It spread at various corners, right? Those are required to, otherwise there has to be a specialized entity.
And in the FIR we have already stated, page 21 you'll also find where it went.
Let Ms. Borman give a short synopsis from that
CD, my
CD.
lordship.
What kind of investigation the IO had
Made
done,
as on
basically? Just bullet point. Who were examined,
lordship.
right? What kind of seizure he made,
Lordship.
then what kind of information he obtained, and specifically after getting the transaction statements from Axis Bank in respect of 3 account numbers,
Lordship.
and also the amounts indicated that how many transactions were committed, right,
Lordship.
was completed through whatever RTGS, NEFT, whatever, to the personal account of the accused, right?
Lordship.
Say, for example, in the year 2022-2023, after minute analysis, Axis Bank found that 44 transactions amounting to rupees 3.42 crore was done, and 2 transactions 0.2 crore into the personal account of the Parmar. So thereafter, Parmar's account was examined or not? This is huge bunch. It will be difficult for me.
Lordship.
So after giving the details, Axis Bank, now thereafter, whether details of Parmar's personal account and where those amounts were siphoned off, if siphoned off. If it is in the bank account of Parmar, it's okay.
Lordship.
Whether he has taken any action after looking at the transaction
Lordship.
and wrote to the bank that to freeze instruction. They were happy. It looks like the entities were happy. They enjoyed
They have already.
the proceeds of crime.
Lots. And he was granted bail as because there was no progress in the investigation. There's still Lana Session has already stated.
But you make a report. This report is not, this report is nothing. So you prepare a report on the basis of this. What kind of steps he had taken from the date of registration of the FIR. Then it will be easier for us. We just recorded, you'll go to the SDI and apprise this court about the steps taken by the IO. Hired Mr. D. Taldan as senior counsel listed by Miss A. Biani, learned counsel for the petitioner. And Miss M. Borman, learned junior government advocate Assam for the response number 1, 2, and 3. Full stop. Ms. Borman has submitted that the case diary of Dispur Police Station case number 34/2025 has been received. And she will go through the contents of the case diary in detail in order to apprise this court about the steps taken by the investigating officer of the case after registration of the FIR. Full stop. Which is the case on next week?
After 1 week. After 1 week.
After?
After 1 week.
1 week.
Next Tuesday. Next Tuesday.
2nd June, 2/6. Item 12.
My lord, this is secondary petition. My lord, seeking my lord, permission for composite land sale permit.
Yes, Mr. Sharma, sent for vetting.
Affidavit is filed today.
Filed today. Okay, let it be on record then.
Lordship.
Mr. M. A. Islam, petitioner. A. Aforesaid, petitioners. A. Aforesaid, revenue. 1. H. Sharma, additional
2 and
senior
3.
government advocate. 2 and 3. Present. Mr. Sharma has submitted that an affidavit in opposition on behalf of the respondent number.
Respondent number, Lordship, 3.
3 is being filed during the course of the day. Full stop. As the affidavit of the respondent number 3 is being filed today, let the case be listed again on so and so with the said affidavit on record.
4th June, 4/6. Item 14.
Additional reinforcement.
Additional?
Reinforcement. But Mr. Mishra is there, but I have also been included in the case.
Okay. Standing Counsel, Income Tax Department.
Yes, sir.
Yes.
Worship, in this case, mainly the points which has been raised in this writ petition is that they are asserting that they have not received any notice. And secondly,
Now, what is the case about? I don't know. So you were reflected. So what is this issue? Debit freeze.
Yes, what has happened, but there was an assessment against me, my lord, and no notice was there, my lord, and the bank has attached my account, freezed my account. So we have come up before your lordship challenging that order. In between, what has happened, my lord, we had filed a appeal, my lord. There was no condonation that was dismissed. Then we approached ITAT, my lord, Income Tax Appellate Tribunal. the delay has been condoned, the matter has been remanded to CIT for fresh adjudication after condonation of delay. So, my lord, that.
What is this 16 to 2026?
No, this is an email by which, my lord, I have
Which
been
page?
copied. At page 62.
As per income tax order. As per income tax department order.
Yes. But that has not been communicated to us, my lord. There is, perhaps there is an attachment order by virtue of which the bank has.
Now, what proceeding you are preferring before tribunal or what?
But before.
There is an
tribunal-
assessment order.
Yes, yes, there is an
Let
assessment.
us see the facts just for our.
Yes, my lord.
Allegation is that you did not file return. 2017-18.
Yes, my lord, and no explanation was given, my lord. And my lord, very surprisingly, even
148AB was issued to SSC. The case of the order number 40 it has been passed by the judge. Notice and section so and so was issued. Region for selection. Variation is proposed. Use of text of SCN should produce. Show cause notice. Rejection of rules, amount credited, survey income, bank interest income, synopsis. So this is a notice under what? This is an order.
this is an order of assessment, my lord.
147,
Yes.
reduce 144, reduce section 144B of the income tax. 15/3/2023.
Yes.
Then what happened?
Lord,
Thereafter, after 1 year, they preferred an appeal before the Honorable Commissioner Appeals.
Commissioner of Appeals. Okay.
That was rejected directly on the line of limitation because they did not file any petition for condonation of delay. That is in page number, Lordship, in page number 38.
Page number
38.
250.
$325 delay was there.
Page 41.
Page 41. There are 2.9.
Limitation act is applicable.
But there is a
Limitation
limit
given in
prescribed
Income
in the
Tax Act.
statute itself.
Is applicable.
Yes.
Eventually, Lord, we file an appeal at page 42.
No, the point. They say that no sufficient cause was shown.
Yes.
Because no application for condonation of delay. Okay, thereafter?
Thereafter, an appeal was made before the Honorable Income Tax Appellate Tribunal. Without going into the facts, Income Tax Appellate Tribunal remanded back the matter before the Commissioner Income Tax Appeals.
No one present from the Okay, then
The matter is remanded, condoning the delay, the matter is remanded back to the Commissioner Appeals and it is pending.
Now, what is the reason for putting this account
on hold, on debit freeze. Lordship, for this, you will have to understand, Your Lordship, that after an order of demand is passed against the necessity, Lordship, then a notice is required to be issued under Section 156 of the Income Tax Act, which is called the demand of notice. As they've alleged that they've not got any notice again under the Income Tax Act about the said demand, that has been annexed by them in Annexure 2 itself, Annexure B, page number 37. That is our notice.
Page number
37.
37. What does it notice?
Under Section 156 of the Income Tax Act.
This is to give you notice that for the assessment you can for details. Retirement is payable. I am not sure it pays the manager.
Scheme of notice है.
Last line is regarding what? Regarding the assessment order.
Yes, sir. Regarding assessment order.
Regarding
If he
the
wishes
assessment
to offer
order.
any appeal, then they may.
Regarding the assessment order.
Clause 5.
What is 156? What did they say?
156.
You will take the recourse to recovery proceedings.
No. Lordship has asked what is 156? Married, Lordship. When any tax, interest, penalty, fine, or any other sum is payable in consequence of any order passed under this Act, the assessing officer shall serve upon the assessee a notice of demand in the prescribed form specifying the sum so payable. So this is the notice of demand which is required to be served upon the assessee.
Okay. Where is the power to freeze the account?
Yes. After that, Lordship may kindly peruse to Section 220, subsection 1A.
220?
Subsection 1A. Means this notice which has been issued, it shall remain applicable. It shall remain enforced.
1. 221.
220, subsection 1A.
220.
220.
220.
Married. Where any notice of demand has been served upon an assessee and any appeal or other proceeding as the case may be.
Okay. Subsection 1?
A.
A. Yes.
Where any notice of demand has been served upon the assessee and any appeal or other proceeding as the case may be is filed or initiated in respect of the amount specified in the said notice of demand, then such demand shall be deemed to be valid till the disposal of the appeal by the last appellate authority or disposal of the proceedings as the case may be, and any such notice of demand shall have effect as specified in Section 3 of the Taxation Laws, Contribution and Validation of Recovery Proceedings Act. It means when this notice has been issued, it shall have effect until unless the last appellate authority, that is up to the apex court, this notice of demand will be having effect. This will be effective
Remain valid.
until unless there is any change. If there is an enhancement of demand, then only for the enhanced amount a new notice will be issued, and if there is any reduction of amount, then only intimation will be sent to the assessee, but no new notice of demand will be raised upon the will be issued to the notice to the assessee. So my notice is already there. Now, so far the recovery and the freezing of the account is concerned, Lordship, the time limit is given, which is 30 days. Once within 30 days, if the amount is not paid, then he is be considered as an assessee in default. And once he's considered as an assessee in default, then there are two provisions from which recovery could be conducted. One is section 222 and one is section 226. Here the department has proceeded under section 226.
What is 222?
222 is basically when the movable properties and immovable properties have been attached and they are sold. In that, a certificate is raised and other procedures have been carried out. But here we have proceeded under section, the department has proceeded under section 226, other modes of recovery.
Yes.
When no certificate has been drawn up under section 222, the assessing officer may recover the tax by any one or more of the modes provided under this section. Where a certificate has been drawn under section 222, the tax recovery officer may, without prejudice to the modes of recovery specified in that section, recover the tax by any one or more of the modes provided in this section. Here, Lordship may kindly come to subsection 3. Subsection 3. The assessing officer or tax recovery officer may, at any time or from time to time, by notice in writing, require any person from whom money is due or may become due to the assessee, or any person who holds or may subsequently hold money for or on account of the assessee, to pay to the assessing officer or to the tax recovery officer, either forthwith upon the money becoming due or being held, or at or within the time specified in the notice. So here it covers banks also. This can be covered, Lordship, it may be clarified by clause 4. Save as otherwise provided in
Just a minute.
Lordship.
Yes. Which section?
No, this section, clause 4. Save as otherwise provided in this subsection, every person to whom a notice is issued under this subsection shall be bound to comply with such notice, and in particular, where any such notice is issued to a post office or a banking company or an insurer, it shall not be necessary for them to issue for any having any passbook, deposit, receipt. It means that this section 226.
Let us read totally.
Oh, yeah. Where any such notice is issued to a post office, banking company, or an
Every
insurer,
person to whom.
it shall not be necessary for any for
This subsection. Who is the notice?
What is this page number 37?
This is the petitioner.
Petitioner has annexed this notice.
No, my friend is, there has to be a separate notice if you take an action under 226, because your lordship.
To the bank.
Clause 5, if your lordship sees.
Where is that?
That is not there, Lordship.
Huh?
That is our
That
case.
is why you are standing for? Yes. When a statute prescribes a mode
Yes, Your Lordship.
and a manner in which an act is to be carried out,
Yes.
it must be in that mode. So where is your notice? Petitioner is not aware what kind of notice the bank has received.
Does your lordship sees page 37?
You
they
should
say-
come up with instruction. You are taking
No,
into
no,
that.
I'm not understanding with this, should be asking for this notice. I'm having that.
Nowadays, it's small, all e-portal through it's done, my lord. In the portal also, we could not find. We made a statement to that effect.
So it has been done.
It's been done.
But we have not been provided with. That is our.
Otherwise, this is
Yes.
not.
Otherwise, also, my lord.
But you were aware of the claim.
Yes, yes, we were aware of the.
Now bank has come up, bank have said that they have received on 19 to 2024. And that is after much later than the initial notice under section 156 at page 37. That was on 15/3/2023. And
is
this
dated-
letter has been 19 to 2024.
19 to 2.
What infirmity?
No, Lord. Otherwise, also, Lord, we don't have that much of. But in fact,
No
we
infirmity.
may have a different remedy, Lord. But if Lord, they decide my CIT appeal, Lord, all issues will be resolved, Lord.
No, how can you cannot direct an independent tribunal?
No, Lord, because since it's arising out of that, Lord, now it's been remanded back. It's only a matter of.
Already I have seen appellate tribunal condoning the delay.
Now it's pending before CIT.
You ask there. If that demand is removed, this automatically will end.
Yes, yes, Lord. In fact, Lord, it's been structured in a manner, Lord, I cannot improve upon.
Are you having any gold mine in that bank account?
No.
18,000 rupees only. Your Honor.
Then
Lord,
wait, you can wait for your turn. 18,000 rupees.
no,
They have
yes,
recovered out of 25 crore only 18,000 rupees.
Lord, dear Lord.
Yet not recovered, Lordship.
In fact,
No, what infirmity?
no, Lord, infirmity.
So
Lord,
tell me, we are only concerned with infirmity in the process.
my lord, I cannot improve upon the case that has been projected, my lord. But the fact of the matter is, my lord, that is-
Better you draw with liberty.
that your lordship may give, my lord, that.
If
Or not,
anything
when I
arises
provided a
later
copy
on.
of that attachment order, my lord.
Mr. Okay, this is your notice. Mr. Standing Counsel, Income Tax Department,
Yes,
can it be handed over to Mr.
Yes, yes.
Otherwise, my
from
lord,
your side?
Yes, Your Lordship. I have.
otherwise, my lord, it should be.
You have?
Yes.
Then hand over.
At that time, I did not understand which notice his Lordship was asking.
Hand over a
Yes,
copy.
That will-
I will.
Nothing.
No, I understand. But there could have been better ways, my lord. Even I have, it's similar to you, my lord, use transaction assessment, my lord. My lord will see it's a very unique assessment made. Even my deposit.
So
will
your
count
claim is
3,000.
25 crores minus 18,000.
No, my lord, what, anyway, my lord, this is.
Mr. R. Dubey, Learned Counsel for the petitioner, Mr.
J. Chopra.
J. Chopra, Learned Standing Counsel,
Yes, Lord.
Income Tax Department, for the respondent number 2,
It's 2
3,
to 5.
4, and 5. And Mr. R. Chakraborty, Learned Counsel for the respondent number 6. First up. As Mr. Dubey has been handed over a copy of the notice issued under section 226 within bracket 3. Notice dated
220.
19/2/2024.
Yes.
Issued under section 226 within bracket 3 of the Income Tax Act.
1.
1.
226 bracket 3 clause 1.
Bracket 3. Clause 1 of the Income Tax Act 1961.
1960.
Now it is new act has come.
New act has come.
1961. Whereby the bank account Number so and so. Whether the bank account or the petitioner maintain that respondent number 6 bank has been kept on hold. Hold,
debit
freeze.
freeze, debit freeze.
Has been debit freeze. Post of. Withdraw or dismiss?
Withdraw, my lord.
Mr. Dubey, having received a copy of the said notice, has submitted that the petition and submitting that since the appeal preferred against the assessment order dated
15/3/2023.
15/3/2023 is presently pending before the
PIP.
appellate authority.
Yes, first appellate.
First appellate authority. The petitioner wants to withdraw the writ petition with liberty to approach again in the event of any subsequent cause of action.
That liberty be given, my lord? We can approach the CIT also, my lord, because this is interconnected, the demand is connected with the appeal.
In order to avail appropriate remedy, in order to seek recourse to appropriate remedy as permissible under the law, in view of the above submission made by Mr. Dubey, learned counsel for the petition, the petition is dismissed on withdrawal with the liberty as sought for.
I was, but this is not within the scope, lord. If you can approach the CIT for early disposal, lord, that liberty, if your lordship.
Yeah,
I
you
know.
go there, you go there.
Because lord, notice you remanded back in August, lord. Still, we have not been issued notice.
How can we? Now Supreme Court has said we are not passing any direction to the High Court that finish this matter.
My lord. No, no, I'm not.
So similarly, High Court passing the order, finish the proceeding within 1 month, 2 months.
No, I'm not. Only to liberty to approach the authority.
You approach. It is pending already.
Yes, but the process takes.
If
It
they
is
want
pending
to
already.
Stay, Lordship, there is a provision to, if they want to make a stay, they will have to deposit 20% of them.
Go there. Next.
No, I am on the main appeal.
Obliged.
Mostly obliged.
Items 15 and 16.
Some form instruction have been received, we are going to pay for some time. Yes. Anything, affidavit,
You can leave it as 2.
file.
The instruction has been received, my lord.
Last that it was the submission.
Yes, my lord.
Instructions have been received and prays time to file affidavit. So you are renewing prayer. Okay. In both the cases.
Only 16 I have received. A similar case file.
So one affidavit will do.
Both the cases.
Petitioner is same or what?
No, petitioners are different, but issue is same.
Okay.
It's a
Which আছে? Okay, we take a look at the P.K. Rochuri, Learned Senior Heart, Mr. P.K. Rochuri, Learned Senior Counsel, estate by Mr. Swainson, Learned Counsel for the petitioners. And Mr. Doctor, you were there?
Yes.
Okay, Learned Standing Counsel, Panchayat and Rural Development Department for the respondent number. File of Panchayat Rural. Tell me that.
I'm for 345.
And Mr. Das and Das, Junior Government Book Assam for the respondent number
345.
345. Revenue. Aforesaid. Revenue, revenue side of.
I'm 1 and 6.
You were there. You were 1 and 6 means who?
I'm 1 and 6.
Okay, Doctor 1 and 6. Okay, Mr. Das has renewed the prayer for filing of the affidavit in opposition on behalf of the respondents represented by him and has sought for further 3 weeks' time to file the affidavit in opposition. The prayer is allowed. Release the cases on so and so.
1906. 19, I will be out. 22nd. Item number 17.
Yes.
The pertains to Lordship, cancellation of GST registration without fulfilling the mandatory criteria of 30 days notice, Lordship.
Where from 30 days is there?
Lordship is there in section
Sound it.
Yes.
Lordship.
Which rule?
Rule 21, 2A, 2AB, Lordship.
21. Twenty-one, two?
2A, Lordship. Sub-rule B, Lordship.
21
CKST.
There is suspension. Okay. Yes.
I got on similar matter, Lordship.
Hmm. It is there.
On this point, perhaps my affidavit is silent. Instruction is silent, my lord.
Instruction is silent, but there are
My lord.
findings in
Registered person.
other judgments. Two A B.
Yes, sir.
Oh. Yes.
It will be on Friday, my lord. I will just.
Notice does not
Yes,
say,
my lord.
it gives 7 days, but two in,
Within a period of 30 days.
That means at least 30 days, Lordship. But
and what purpose is going to be served to the department?
My lord, here, my lord, the
Firstly, it is,
restriction has been kept,
otherwise,
my lord.
if it is otherwise, show cause notice.
For non-furnishing the details of the bank account, it has been, my lord, cancelled.
Yes.
That
Rule
is
10A.
10A.
Rule 10A.
Yes.
that has been corrected, my lord.
Huh.
On page 43 to 51, my lord, if your Lordship may kindly peruse.
40.
3, Lordship. The amendment application has been done and thereafter we have filed our all the up-to-date return, Lordship.
Now what is the difficulty then? You have activated?
Not yet activated, Lordship. That,
Not yet activated.
yes, sir, Lordship. That is why I'm
Directed to furnish a reply so far as Mr. Gogoi Soko's notice GST REG 17 is concerned, it is okay. But
the page number here.
contravention or provision by the registered person. Or rule chaining. So reading both together, rule 22 and rule 21A also, capital A. Though 22 1 says 7 days.
Lordship.
But at the same time, 21 2AB indicates about period of 30 days as to why his registration shall not be cancelled due to contravention of Rule 10A. These are not
Lordship.
assimilating under 22 7 days. But here It indicates about 30 days.
Well,
Yes, anything. Even on Friday.
I will let you on Friday. At least I will address on that.
Okay. You go through the orders.
My lord.
Annex also.
No, my lord, detailed instruction has been furnished. That's why. Let me.
No, on the rule.
Yes.
Basically, the coordinate bands, I am not observed specifically, but the coordinate bands state, when a statute prescribes a thing to be done in a particular manner, then that thing must be done in that particular manner, in no other manner. That is the only.
Page number 50.
It doesn't pass by a lordship.
I have also, but the coordinate bands are specific. In a specific manner has indicated that that must be done in a particular manner.
Lordship, sir.
Okay. S.K. Saha, petitioner. Is present, on the request of Mr. B. Goel, standing counsel, Finance and Taxation Department, list the case on so and so. To complete his instructions. Friday.
2905.
Published.
Item 18.
Mr. Bhuya and Mr. Kyle.
Lordship, as per your last direction, I have got the judgment of Justice Korean Joseph, where the MP still was made not res integra anymore. I have the judgment with me, Lordship, if I can
Res
serve a
integra.
copy. Yes. Sir.
Mr. Jain,
Lordship.
what do you propose? We keep it part or some other day?
Lordship.
Not possible to the kid now. Yes, Sujus or Crow.
Yes, Your Lordship.
It has been reported in SCC also.
Yes, Your Lordship.
Yes, Mr. Jain, where is Mr. Kyle?
Lordship, he has left the court.
Will he be available next week?
Lordship is available.
Next week. Possibly we'll take it up on 4th of June, 3 p.m. because maybe in the next week I'll be sitting.
4th of June, Mr. Kyle will be out. Lordship, we will be in Itanagar bench. Any day before or after lunch.
Before after it will থাকি গ'ল না এইটো তো 2 তাৰিখে থাকি গ'ল সেইটো ডিটেকশন দি থৈ 1.5 ঘণ্টা যাব
কন্ট্রাক্ট লেবারটো আছে
ও
16 তারিখে তো কনসাল্ট আছে 9 তারিখে
তাৰিখে দি থৈ যাম কোনটো আছে নহয় এইটো 3 তাৰিখে শেষ কৰোঁ হা 3rd of June.
Lordship.
Well, there is an interim order that might kindly be
I, Bhuya, petitioner. And Mr. K. Jain, learned senior counsel and special counsel, CGST for all the respondents. As the submissions of the learned counsel for the parties are not complete, raise the case again on 3/6. The case will be taken up as partner, and the case is to be taken up at 3 p.m. Any time or a past Friday shall continue full and
Much obliged.
Should be recorded.
Mr.
Estacoti.
Standing Central Government Council.
Central Government.
Only on the point which are on the agreed line as Mr. Kyle.
Lordship.
deeply obliged.
So I'll take up more matter today. Admission. Time being Kuntu.
Timing matter. Item 3.
Oh.
Milord, I'm sorry, Milord, I was on lag, Milord. Milord, this matter relates to a bus stoppage, Milord.
I'm not here today.
My lord can fix it on next week, any date, convenience of my lordship.
Yeah. Listed by Mia Hussain. Who is for the state?
Eight.
K. Kolita. Respondent by 8. Mr. P. Dotto.
M. Dotto.
M. Dotto.
Malab for 9, 10 and 11.
9, 10, and 11. Others are not there. What is the issue about?
Lord, the issue about is that a parking lot had been allotted near the Bokakhat town, Milord, for the purpose of parking of 2 buses, Milord, for just to dropping and pick up of passengers. Now, Milord, the
What is the urgency to be listed in the next week?
some dispute.
I don't think. It is not a matter of
Lord, our business has been.
personal liberty. It is a business.
Milord, business is.
Business of entities.
Milord, our business has been used up by my learned friend, Milord. That's the problem, Milord.
My lord.
Later, sometime.
My lord.
23rd June.
23rd.
My lord.
Yes, Mr. Roy.
My lord, one item, of course, is not possible, my lord. 24 item number.
Not possible, sir.
8 and 4th, my lord.
No. Already matters are posted fourth.
Then my lord, 9th.
Later. Near about this thing.
18th, my lord.
June.
July.
18. J. Roy, Senior Counsel. And who is for the revenue?
I appeal.
A. Authorized revenue. No. This is the case. Supervisor and counsel for the parties. Yes, Mr. Gore.
Cancellation of lease.
Huh?
Cancellation of lease. So, cancellation of lease of the petition.
Cancellation of lease of the petition. Which one? Item?
Item 23, Malur. 22, Malur. 23.
Okay. Counsel is present. AIDC.
No,
Okay.
Mr. Dekha is.
Mr. J.C. Gold, Learned Counsel for petition is present as the Learned Counsel for the respondent. AIDC is absent today on call. Let the case be listed on. After vacation?
Malur, they had already dispenser my factory, Malur. In spite of they have dispenser my factory, Malur, in spite of pendency of this state petition. Earlier date may be given.
Sorry, later. We are on the